Sharing photos of patients on social media has become increasingly common. My name is Erin Jackson with Jackson LLP Healthcare Lawyers. As a healthcare business attorney, I often cringe when I see on social media pictures of healthcare providers or practices with their patients. Why is this? Because I'm rarely asked by my clients if this is something that's acceptable to do. Here's 3 reasons why you might want to hesitate before sharing that picture. The first one is HIPAA. This seems obvious, but it's often not. HIPAA requires that you be very careful with sharing a patient's PHI or protected health information. Unsurprisingly, their identity is protected health information. Just because that student athlete who you help recover from ACL surgery or that pro football player who's excited to be back on the field is beaming and in your practice and willing to take pictures today doesn't mean they're going to want to be on your Facebook a year from now. So it's important to obtain HIPAA compliant written consent to sharing their photo on social media. This is different than a lot of ways that you might obtain their consent to share information. You're not sending it to another treating provider. You're using it for your marketing purposes. And a whole nother ballgame of rules applies for that under HIPAA. 2, the Illinois Biometric Information Privacy Act. It's a mouthful, but HIPAA is one of the strictest biometric protection laws in the country. Anyone in Illinois remembers every once in a while an app on Facebook won't work in the state because it tries to match your face up with the face from a famous painting or a celebrity's face. And this is because it requires scanning of biometric details, like the distance between your eyeballs, and isn't in compliance with HIPAA, an Illinois biometric law. So HIPAA requires that you maintain policies about how you'll collect, manage, store, and disseminate biometric information. You're not collecting biometric information, you say? It's just a photograph. Actually, the courts, while they don't all agree on this, view a photograph as the old floppy kind of photograph that you print at Walgreens and then put in a frame at home. They say today's high-res photos are a whole nother ball of wax. So it's really important that you protect patients' information. Did you realize that some of the photos you share on social media can be printed on a high-res printer now and actually used to access retina or fingerprint scanning devices, EMR systems, bank systems, anything like that, just with a photo you share on social media? It's both terrifying for providers, but also for their patients. 3, your Practice Act and ethical rules. A lot of providers' practice acts speak to how they can or should use patient testimonials on their websites or in marketing. Some expressly prohibit providers from soliciting testimonials from their patients. Can a photo with you potentially constitute soliciting a testimonial? It depends on the wording of your Practice Act and your ethical rules. And it's crucial that you not run afoul of those if you want to stay on the good side of the Illinois Department of Financial and Professional Regulation, or the IDFPR. They're the ones that license you, and they're the ones who can unlicense you. So it's really important to keep all these things in mind. And while it seems like a really simple thing to take a cell phone picture with one of your patients and share it on social media, it actually could run you afoul of a massive amount of laws. It's crucial that you have written releases in place for your practice that are specific to your patients and what you might be using that information for. If you want to learn more and stay tuned about how to keep your practice compliant, just follow our YouTube channel.